Hear ye, hear ye, hear ye. All manner of persons having anything to bring before the Honorable Justices of the Supreme Court of the State of Delaware will now draw near and give their attendance. The court is now open. God save the state and the Honorable Court. Please be seated.
Good morning, everyone. Welcome, Capitol Police. Thank you for being here today. Mr. Nachbar.
Good morning, Your Honors. Kenneth Nachbar, Morris Nichols, Arston Tunnel, here on behalf of the Williams Companies, Inc. I have a few introductions. First, and probably most importantly, Anthony Ryan of Cravath, Swain & Moore, who will be arguing on behalf of Williams. Also at council table, Kevin Orsini of Cravath and Michael Addis of Cravath as well. Also in the courtroom are Lane Wilson, General Counsel of Williams, and Carissa Cottom, who is the Vice President and Assistant General Counsel of Williams.
Welcome, everyone.
Thank you.
Good morning, Chief Justice Seitz, Justices James Yock, Young, Conway, Stargett, and Taylor on behalf of appellants Energy Transfer LP, Energy Transfer Corp. LP, ETE Corp., GP LLC, LEGP LLC, and Energy Transfer Equity GP LLC. I rise to introduce first client representative Sam Hardy, who's head of litigation at Energy Transfer. And at council table, it's my pleasure to introduce from Clement and Murphy, Paul Clement and Matthew Rowan. And also from my firm, my colleague Alberto Chavez.
Welcome, everyone.
Thank you, Your Honor. Mr. Clement has been admitted pro hoc vice, and with the court's permission, he will be presenting argument on behalf of the appellants.
Please proceed.
Mr. Chief Justice, Your Honors, and may it please the court. In September 2015, Energy Transfer and Williams agreed to a merger to be closed 9 months later in June 2016. The agreement contemplated that Energy Transfer CEO would serve as the CEO of the post-merger entity. Perhaps for that reason, Williams CEO Alan Armstrong was never a fan of the merger. But in the merger agreement, Williams and its board agreed to adopt resolutions supporting the merger, which could not be modified or qualified, and to use their best efforts to complete the deal and resist litigation challenging it. Those best efforts never materialized. To the contrary, Armstrong worked hard to sabotage the deal in multiple respects, including conspiring with a litigant challenging the merger and then destroying evidence of the communications and lying to cover up that intentional spoliation. Despite all that, the Chancery Court concluded that Williams was entitled to a $410 million breakup fee and that Energy Transfer could not even pursue discovery on its counterclaim for its own breakup fee. The Chancery Court appeared fixated on the fact that Energy Transfer declined to close because of the parties' inability to secure a necessary tax opinion, and Williams purported to be ready, willing, and able to close despite their own best efforts to scuttle the deal. By June 2016, it was clear that the deal would not close, and Williams was simply posturing for the breakup fee. In reality, after the energy market collapsed in late 2015, it made little sense for either side to pursue the deal without modification. In that context, Williams' behind-the-scenes efforts to sabotage the deal while purporting to be ready, willing, and able to close made financial sense, but hardly excused the machinations of Williams in general and Armstrong in particular. Now, in our view, the Chancery Court erred at the outset back in 2017 when it dismissed Energy Transfer's counterclaim on the pleadings. That dismissal rested on a mistaken reading of the merger agreement and the untenable view that as long as the board did not withdraw its formal, non-public resolutions of support, the board, Williams, and Armstrong were all free to publicly criticize the deal and make clear to markets and shareholders that a sizable minority of the board continued to oppose the deal.
So let's start with the board recommendation. What were the technical requirements under the contract?
So the board recommendation was to pass the resolutions. There are 4 specific resolutions that they had to pass, and all of that, of course, is consistent with the requirements of Delaware law. And those requirements, of course, had to be done by the board.
And that was all done. There's no contest with that piece.
No contest about that.
Right.
But Section 402D, which prohibits a company adverse recommendation change is written in broader terms, and it prohibits the board or any committee thereof from modifying or qualifying those board recommendations, or even proposing publicly to withdraw or modify those recommendations. And it's really...
Isn't it the case that whenever there was a negative statement, there was also a reaffirmation by the Williams board that they were committed to completing the merger? I mean, I looked at some of the releases, April 14th, 2016, and the other ones, and they all have the sentence, "The Williams board is unanimously committed to enforcing its rights." Is there any communication that was not accompanied by such a reaffirmation?
Well, there was definitely communications that were not complemented with a affirmation of uniform or unanimous support. And I think the most important are the 7th and 8th amendments to the S4, which are in May of 2016. And after all those affirmations of unanimous support, all of a sudden, Williams amends the S4 on behalf of the board. So whether, the argument that it has to be the board as opposed to the company is kind of irrelevant with respect to the S4. So on the S4 amendments 7 and 8, after all those statements about unanimous support, they now say that both that the original board vote was divided and that the minority continues to think that the merger should not go forward. And I think if you think about the language of 402D, which prohibits a modification or qualification in any manner adverse to Energy Transfer, that seems to perfectly describe that statement that a minority of the board continues to oppose the deal. That is, in a sense, on behalf of the board, a qualification or a modification of what went before, which were all these uniform, unanimous statements of support. And so that's to me the clearest example of something that was sufficient under 402D and that we should have been able to go forward past the pleading stage. I think if we had been able to go forward past the pleading stage, this case would have proceeded in a very different way. I mean, in all candor, if both sides had skin in the game, this whole thing may have settled long ago. But back in 2017, essentially the exposure of Williams was eliminated based on the pleadings, and I think that is a misreading of 402D and the agreement. So I don't think that's the sole error in the proceedings below, and I'm happy to move to what I think is the second most significant error in the proceedings below, and that is the rejection essentially of our affirmative defense that Williams did not engage in its best efforts, or essentially broke its promise to engage in its best efforts to consummate the merger and cooperate with Energy Transfer to resist litigation challenging the merger. And here we have this extraordinary situation where Armstrong, Williams' CEO, is not just not cooperating with Energy Transfer to resist litigation, but he is actively conspiring with somebody who is threatening litigation against the company.
Aren't you fighting the trial court's factual findings here?
A little bit, Your Honor, but not entirely. I mean, look, I don't make my living making arguments about clear error, but this looks to me as clear an error on the factual findings as I've seen. But that said, I think those clear errors to me are only explicable if you understand that the Chancery Court made a legal error in analyzing what happened. Because, as we point out in the briefs, there's really a focus on the intent behind what Armstrong was doing. And I don't think intent is relevant. Even if he had a reasonable intent, that doesn't map onto best efforts to cooperate in resisting litigation. And I'd really focus on the word cooperate, because at no point, I mean, even if he is in a position to decide, I'm going to try to talk this guy down from the ledge and not have him bring the suit, I mean, he's made a best efforts pledge to cooperate with Energy Transfer. At no point did he share this stratagem with Energy Transfer. He didn't even share it with Williams and Williams' general counsel. And the other thing that doesn't wash about the finding that I think ultimately underscores that it's based on a legal error is that the theory is essentially that Armstrong was working Baumgartner, who he knew, in order to dissuade him from bringing the lawsuit. But that doesn't explain why he continued to talk to him after the lawsuit was filed. And there are continuing communications after the lawsuit is filed. It also doesn't explain why, at the moment the efforts failed and the lawsuit was filed, why at that point wouldn't Armstrong come clean with both his own general counsel and with Energy Transfer's lawyers, both of whom he's made a pledge, the company's made a pledge, to engage in their best efforts to cooperate. So, so even if you take all of the findings of the Chancery Court as a given, it doesn't map on to a conclusion as a matter of law that there were best efforts to cooperate, to resist the litigation against the merger. And that seems to me, for purposes of the posture of this case, if we'll put aside 402D for a second in our counterclaim, but for purposes of this is just a defense to their claim. And it would mean that as a practical matter, essentially both sides walk away from this, nobody gets a breakup fee, and that seems consistent with the idea that when the energy market collapsed, both parties realized that the deal really couldn't go forward without modifications, and the deal eventually didn't go forward. Now, the Chancery Court seemed to think, in addition to whatever factual findings it made, it also seemed to think that the fact that Williams showed up in June ready and willing to close was sufficient to say that there was, essentially, I don't know, where it stopped, or there's no material breach, or they cured. And with respect, I think that is also mistaken, because, I mean, for one thing, by the time that Williams shows up in June to close, this litigation over the tax opinion and their efforts to have the merger sort of go forward, all of that's happened. That's happened before the shareholder vote. So in a sense, everything that happens after that might be necessary for Williams to try to preserve its claim for the breakup fee, but it doesn't show sort of kind of in substance that they were fully supporting the deal. It just shows that they wanted to perfect their right to potentially ask for a breakup fee. So I think it's wrong to focus on that and say, like, well, obviously Williams wanted to go forward and Energy Transfer didn't. The other problem is the best efforts covenant's not a best efforts for the day of closing. It's a best efforts during the entire 9-month period between the inking of this deal and the closing. And those are 9 very critical months. Energy Transfer's in a position where it's obligated under the agreement to come forward with $6 billion in cash. And so there's a reason for that best efforts clause, and it's not the kind of thing that can be essentially expunged or wished away after months of misconduct just by simply showing up to close. And I think it's quite distinguishable from other situations that the Chancery Courts had previously. There's the Acorn case, for example. That was a company that for 1 week was in breach of its covenant to try to get antitrust clearance as quickly as possible. And after 1 week, it abandoned the strategy that would have been a more delayed strategy, and for the entire rest of the period, they pursued antitrust approval as expeditiously as possible. Here you have months of conduct that's going on, and to say it was cured by the time of closing also, again, ignores the spoliation and the perjury to cover up the spoliation in this case, because at the point of closing, we didn't know that Armstrong was conspiring with Baumgartner. And we certainly didn't know that he destroyed his account. We certainly didn't know he was then going to lie about it in court. I mean, all of that goes to the best efforts clause and its breach. And I think.
So are you claiming that the Vice Chancellor abused his discretion in the remedy for the spoliation?
We are contending that. I mean, but we also are making the independent argument that even if you don't get to the remedy for spoliation, you would still say that we should have prevailed on our affirmative defense of a failure of best efforts.
So he was wrong about the fact that there wasn't any prejudice because the emails could still be retrieved.
Absolutely, Your Honor, and he was principally wrong as a matter of law because, and this is why, I stumble a little bit over abuse of discretion. We all know that the classic abuse of discretion is an error of law. And I think in considering the spoliation remedy, as I read the Chancery Court's opinion, it put the burden of proof on us to show prejudice. And I think that's wrong, especially under circumstances like this where the spoliation is intentional. And I think it gets really to the heart of it because the explanation, as you articulate, for why we didn't suffer prejudice is we got all the emails from Baumgartner and we didn't show that there were emails to other people. But how would we know everybody that Armstrong potentially emailed about his efforts? I I mean, you know, they're like, we could speculate about certain people, but who knows who he's emailed? I mean, he could email a golfing buddy who also knows Baumgartner and say something that's material here. And if he did that in his Gmail account, that would be wiped off the face of the earth. We wouldn't have access to it. And that's, I think, precisely why, under circumstances like this, you put the burden on the intentional spoliator. You don't put the burden on the victim of spoliation, because how are we to know? I mean, it seems to me almost implausible that there wasn't a single other email in that Gmail account that would have been at least marginally relevant to our cause. But what am I doing? I'm speculating. And when somebody destroys an entire email account, you're going to have to speculate. And it seems to me pretty obvious where sort of the burden of proof ought to be under those circumstances. It should be on the victim to come forward with some whiz-bang theory that, yeah, no, we really do think that that Armstrong was emailing with third parties, and we can identify those third parties, and we've subpoenaed some of those. I don't think the burden should be on us in that situation. Now, like if the burden's on the other side, that doesn't mean they automatically lose. Maybe they backed it up. Maybe there's some other way to kind of demonstrate to a certainty that the spoliation didn't have a greater prejudicial effect. But the burden has to be on the spoliator. It can't be on the victim of the spoliation. And I think that's a legal error, and that goes to the heart of the error. I suppose you could send it back for the Chancery Court to put the burden in the right place and then exercise discretion. But under the circumstances of this case, I think it's pretty clear that if the burden's in the right place on this issue, then there is a breach of the best efforts clause. There is an affirmative defense. Doesn't mean that we're entitled to money on this theory. It just means that Williams doesn't get $410 million for a merger that didn't happen, that Armstrong admittedly tried to oppose, at least in some respects, because there's a factual finding that suggests that this interaction with Baumgartner was intended to forestall his suit. But there's plenty of other evidence in the record that Armstrong opposed the merger, was working to talk to other board members to fortify their opposition to the merger, try to swing some of the swing votes, because the original vote was against the merger and then 2 votes swung, so he was working them behind the scenes. So there's plenty of evidence of kind of violation of that best efforts covenant here. And I think if you put all of that in the context of these destroyed email accounts, the right inference would be that there was a failure of the best efforts covenant and Williams walks away with nothing. If you reach that conclusion, you don't have to reach the issues of attorney's fees at all, but let me just spend a couple of minutes on attorney's fees, because I do think if you get to that point in the analysis, the attorney's fees issue is an error of law and is actually quite important for Delaware public policy. Because it seems to me that when you have an attorney's fee, reasonable attorney's fee provision between sophisticated parties who are employing the Cravaths and the Wachtels of the world, the obvious inference there is that this is going to be hourly rates, that the reasonable rates are going to be in a traditional reasonable hours, reasonable rates lodestar. And to allow in that context, I mean, I think, Shire can be an exception to the rule, but to allow in that context as the rule that contingency fee arrangements are permissible just because they are reasonable under Delaware Rule of Professional Responsibility 1.5 would be a serious mistake. I mean, as we point out in the briefs, that essentially converts a reasonable attorney's fee provision into essentially an insurance policy where one side or the other can basically not pay any attorney's fees if they lose, because if they lose, there's no recovery under the contingency, there's no obligation under the contingency. But if they win, they pay no fees, and the other side ends up paying double or triple in theory. And
is it your position, excuse me for interrupting, that it is improper to shift any type of contingency or success fee arrangement? Should there be a black letter rule along those lines in your view?
I mean, I think there should either be a black letter rule along those lines or a presumptive rule with a sort of a Shire-like exception for situations where a party can show that's really the only way they could get sophisticated counsel. I mean, I think that exception doesn't bother me. What bothers me is the two things. with respect. One is that this would become the default rule among sophisticated parties who are otherwise going to be
So it
paying.
could be contracted around, correct?
Obviously, we're just talking about what the default rule is.
Yeah.
But here's the second thing that bothers me about it is the logic of my friends on the other side's position is whatever's reasonable for Delaware 1.5 is reasonable for purposes of contractual fee arrangement. Here's why that can't be right. Because as you suggested, it's not just contingencies, it's success fees. And there's certainly, I think it's perfectly reasonable for a client to go to a lawyer in a matter they care very deeply about and say, look, I'm going to pay you your full rates, but I want you to be fully vested in this. I want this to be your highest priority. So on top of your full rates, I'm going to give you a success fee. It's 5%, could be a fixed number, but whatever it is. Now, I can't imagine, though I could be wrong, that that's unreasonable for purposes of Rule 1.5 if it's a sophisticated, well-understanding client and a law firm. But you couldn't say under those circumstances, I don't think, that kind of success fee on top of normally hour rates could be compensable under this kind of reasonable attorney's fees provision. Because if it is, well, then everybody's going to start having success fees in litigation on this stuff because it's essentially costless. If you lose, you owe nothing. If you succeed, the other side pays your lawyers a big success fee. Why not do it?
Your brief focuses on the idea that when this attorney fee provision was drafted in 2015, there wasn't a Delaware case that said that you could shift fees for contingency fee arrangements. Are you aware of any Delaware case that said you couldn't?
No, I'm not, but I think that at that point, at the point of drafting, I think that this case hadn't been teed up, essentially because nobody tried to recover the contingency fee. So I think, in that sense, I think the dog that doesn't bark works in our favor and supports the default rule, which is if it just says reasonable and it's between sophisticated parties who everybody knows are kind of paying Wachtell and Cravath their hourly rates, you leave the default rule there and you don't allow a contingency fee to be shifted unless there's a deviation from the default rule. That seems like the right answer to me. It seems like what the default understanding would have been at that point because nobody had tried and succeeded to shift a contingency fee arrangement under those circumstances. I see my time's up, so I'd save my time for rebuttal. Thank you.
Thank you.
Good morning, Your Honors. Anthony Ryan on behalf of the Williams Companies. So this is the second time that this case has been before this court. The first time it was when Williams was seeking specific performance to close this merger. ETE was allowed to terminate the merger because there was a failure of a tax opinion condition. But that termination right came with a cost, because the parties contracted that if at the time ETE terminated, ETE was in breach in material respects of interim operating covenants, or if representations that were brought down to closing were inaccurate materially at the time of closing, then ETE owed this $410 million termination fee. That was not an arbitrarily chosen dollar amount. That was an amount to reimburse Williams for a fee that Williams had to pay in September 2015 to get out of another deal. ETE had asked Williams to pay that fee to get out of this other deal as a condition to ETE entering into this merger agreement. And that's why the parties picked this $410 million termination fee. And so here, there was a 6-day trial with many witnesses about ETE's breach. And we didn't actually hear anything, I believe, in my friend's argument about ETE's breach. ETE's breach arose out of their issuance of convertible preferred units. And the court below found that this constituted a wealth transfer from non-participating ETE common unit holders, and more importantly here, a wealth transfer from Williams stockholders to ETE's CEO, Kelsey Warren, and 2 other ETE insiders. Among the 3 of them, they subscribed to 85% of these convertible preferred units. The economic equivalence between Williams stockholders and ETE common unit holders was a fundamental premise of this deal. There was lots of testimony in the record about how important this was to the Williams board and its financial advisors, and that economic equivalence was broken by this convertible preferred unit issuance.
I have a question
Yeah,
about that.
please.
The Court of Chancery found that the preferred offering breached the ordinary course covenant, the interim operating covenant, and the capital structure representation, right?
Yes, Your Honor.
And I thought you said somewhere in your brief that that your friends had not addressed or appealed from the finding of breach on the capital structure representation. Can you explain to me what your position is on that?
Sure.
Maybe I misread that.
Sure. So the capital structure representation in section 3.02C1 has two sentences. The first sentence says there are 3 classes of equity outstanding. The second sentence lists the number of units in each of the 3 classes. Only the first sentence was brought down to closing. That meant that ETE could issue additional equity units in one of those 3 existing classes up to $1 billion without rendering that capital structure representation false. Now, ETE's argument in part 3 of their appeal brief about the contract interpretation has to do with lining up sections of the parent disclosure letter with sections of the merger agreement. Their argument is that somehow each exception in the parent disclosure letter constitutes a safe harbor that allows them to then breach any interim operating covenant. And that's not true. And the court below heard extensive extrinsic evidence and found that that wasn't true. But even if that were true, that still wouldn't excuse the fact that their capital structure representation is rendered inaccurate, because this lining up sections issue doesn't apply
And that's
in that
what the
case.
focus was. Is there any different argument that applies to the capital structure representation condition that is separate from the ordinary course covenant and interim operating covenant?
So their only argument, I believe, rests on the readily apparent exception. So in section 3.02C, there is an explanation of how to read the parent disclosure letter in conjunction with the merger agreement. This is the top of A465 of the appendix, and top of A445 of the appendix, and that explains that it's understood that information set forth in one section of the parent disclosure letter shall be deemed to apply and qualify the section of the merger agreement to which it corresponds in number. It then goes on and says, and each other section or subsection of this agreement, to the extent that it is reasonably apparent on its face, in the light of the context and content of the disclosure, that such information is relevant to such other section or subsection of the merger agreement. And so the issue here is, would somebody looking at this exception in 4.01B5 of the parent disclosure letter, seeing that ETE is authorized to issue up to $1 billion in equity, would a reasonable reader say, oh, it is apparent to me that that must constitute an exception to the capital structure representation brought down to closing, otherwise it wouldn't make any sense that this exception exists? And the answer is no, it wouldn't be reasonably apparent, because there were 3 existing classes of equity units, and ETE could issue units in any of those 3 existing classes.
So your friends on that point argued that reasonably apparent should be viewed as something that's logically related to, well, as I understand the Court of Chancery, it used facially necessary. Could you explain why your friends are wrong and the court was right on that analysis?
Absolutely, Your Honor. So they cite to a case that's actually about relevance from a discovery context, and say that that's the context that the court ought to use relevance here. So there was extensive extrinsic evidence at trial that this is a savings clause. So there was uncontested evidence from Williams' deal counsel that this was a savings clause, that he had discussed the savings clause with ETE's deal counsel, and that the idea behind a savings clause like this, which is actually common in Delaware M&A agreements, the idea is if somehow there's an exception in the disclosure letter that can't be met ever without violating something else within the merger agreement, and that was just overlooked. No one was thinking of that unrelated operating covenant or unrelated representation. That's when this exception kicks in. And so there was uncontested evidence to that effect. So let me turn maybe to the two arguments that my friend emphasized. Those had to do with the company adverse recommendation change and with Williams' material best efforts. So let me start with the basic facts that are in the pleadings and that are undisputed relating to the company board recommendation. That is that the Williams board adopted the resolution that they were required to adopt pursuant to the merger agreement, recommending the merger. The Williams board never withdrew the company board recommendation or modified it or qualified it in a manner adverse to ETE. Every one of the public statements by Williams that ETE complains about reaffirmed the Williams board support for the merger, and I will go into that in a moment. Over 80% of the Williams stockholders voted in support of the merger. 2 days later, Williams showed up, ready, willing, and able to close, and ETE decided not to close and exercise its right to terminate the merger, but a right that came with a cost, as I was explaining before. Now, I heard counsel say several times that Williams purported to be ready, willing, and able to close, but there was actually a stipulation, and this is at page B8148. In the pretrial statement, the parties stipulated that Williams was ready, willing, and able to close, and the Court of Chancery found that. So those are uncontested facts that obviously bear on this. So
I'd like to ask you about how this company adverse recommendation works. It seems to me that the agreement contemplates that something short of withdrawing the resolution could be an adverse recommendation. At what level to what extent must the board qualify the resolution to trigger that provision? Well, what kind of statement would suffice short of withdrawing the recommendation entirely?
Your Honor's right. The language in the merger agreement says withdraw or modify or qualify in a manner adverse to ETE. I'm not sure, Your Honor, exactly where that line is, but I know that we are far, far away from that line here, because in every one of the 5 public statements that ETE relies upon, 2 S4 filings, those were the 7th and 8th Amendments, the S4 that counsel referenced, and 3 press releases, every one of them stated in unequivocal terms that the Williams board reaffirmed its recommendation to stockholders to vote in favor of the merger. And stockholders heeded the recommendation. Over 80% voted yes. So this is not a case that we could imagine where somehow a company's board was somehow unclear or said maybe you should vote yes, maybe you should vote no. There might be good reasons not to vote yes. There are hypothetical scenarios that we could imagine there, but our case is so far away from them that it was easy to dismiss this counterclaim on the pleading, which is what the court did below. And so let me just refer to the 7th and 8th Amendments to the S4 that counsel referred to. One of them is on page A1172 of the appendix, and ETE refers in its brief on page 39 to a statement there that certain members of the Williams board voted on September 28, 2015 against entering into the merger agreement, and continue as of the date of this proxy statement/prospectus to disagree with the recommendation of a majority of the Williams board. Now, that was truthful disclosure. It was disclosure that Williams had already made in the very first draft S4 that was filed in November 2015. Stockholders knew all along that this was a split board. It had voted 8-5 in favor of this merger. The sentence on A1172 in this Eighth Amendment to the S4 immediately preceding the one ETE quotes on page 39 of his brief, the immediately preceding sentence says, as of the date of this proxy statement/prospectus, a majority of the Williams board continue to recommend a vote for the merger proposal. I'd submit, Your Honor, that that's a clear, express, and unequivocal statement that doesn't modify or qualify the recommendation. The same thing is true about the Seventh Amendment to the S4. This is on page A1130 of the appendix. There, ETE complains that in this draft S4, the Williams board disclosed that it wasn't going to seek an updated fairness opinion from its financial advisors. There was extensive testimony at trial about why the Williams board made that decision. A Lazard banker came and explained that this was typical and customary practice and why his firm ordinarily would not update fairness opinion. In any event, Williams disclosed that that had happened, and on A1130, the S4 stated, quote, the Williams board recommends that Williams stockholders vote for each of the proposals. Again, a clear and unequivocal statement, and the same is true of the three press releases that I believe Your Honor looked at. They were at A1041, A1056, and A1131. Each of the press releases says the Williams board has not changed its recommendation for the merger agreement executed on September 28th, 2015. So on a record that is this clear and this unequivocal, there is no basis to try to stretch the company adverse recommendation change provision to encompass the type of conduct that ETE alleges here. The type of conduct that ETE alleges, and obviously the court found that this conduct didn't occur, found after a trial that it didn't occur. But the alleged conduct is that somehow the Williams board, the Williams CEO, was somehow trying to prevent the merger from actually taking place, even while the Williams board was repeatedly publicly reaffirming the recommendation in favor of the merger. There are other provisions of the merger agreement, such as the reasonable best efforts provision that was actually tried at the trial, and where the court found in favor of Williams that there was no breach of this reasonable best efforts provision. There are other provisions that would capture such conduct. There's therefore no reason to stretch and read the company adverse recommendation change provision that way. So let me turn now then maybe to the reasonable best efforts defense that ETE raises, and they are relying principally on Williams CEO Alan Armstrong's contacts with a stockholder named John Bumgarner. Mr. Bumgarner was a longtime friend of Alan Armstrong's. He was a former Williams executive. He'd been the head of M&A at Williams. He knew a lot about the oil and gas industry. He looked at ETE's projections of synergies, that there would be $2 billion in commercial synergies, that is, revenue side synergies from this merger, and Mr. Bumgarner was skeptical of that, and he brought a lawsuit not seeking to block the merger entirely, but seeking to have a corrected disclosure made before the Williams stockholder vote. Now, independently, while this lawsuit was actually going on, Williams and ETE revisited the synergies, actually decided that there was a significantly lower amount of synergies available here. And Williams fought Mr. Bumgarner's lawsuit hard. At one point, we had the entire lawsuit dismissed. He then amended, we filed again, and there the court in Oklahoma dismissed most of his claims, left one claim outstanding. Williams was then able to resolve that, was then able to settle that for a corrective disclosure to stockholders 11 days before the stockholder vote. So Williams did everything it needed to do to make sure that this Bumgarner lawsuit did not interfere with the stockholder vote, did not interfere with the party's ability to close. And again, because this was an individual, John Bumgarner, who Alan Armstrong knew well, he decided the best way for him to deal with this originally threatened lawsuit was to meet with him one-on-one and to try to dissuade him from bringing suit and to try to explain to him what these synergies estimates were. And the court below found that was Alan Armstrong's intention, that he was not trying to assist in the Bumgarner lawsuit, that he was trying to discourage Mr. Bumgarner from bringing suit. And this was based on 4.5 hours of live testimony from Alan Armstrong. This was a very long cross-examination, went on almost a full day. Court below was able to observe all of that. There was also 1.5 hours of videotape deposition played of John Bumgarner, who's a non-party witness residing in Tulsa, Oklahoma. And that was then also played. So these were findings based on the trial court personally observing these two critical witnesses for ETE's reasonable efforts
Mr.
defense.
Ryan, what's your response to the other side's argument that Mr. Armstrong's intent doesn't matter for purposes of the reasonable best efforts clause?
I agree, Your Honor, that intent is not an element of a contract breach. But with all due respect, their effort here is to manufacture a legal issue in the Court of Chancery's factual findings. We're talking about an efforts obligation. And so we then naturally ask, what was Alan Armstrong trying to do? Was he living up to Williams' efforts obligation? And the court below said his intent, meaning what he was trying to do, was to dissuade John Bumgarner from bringing lawsuit. The court below, I would submit, was not somehow superimposing some additional state of mind element on top of a defense of here non-breach of the reasonable efforts obligation.
What about improper shifting of the burden of proof on the spoliation?
Yeah, so again, that is also an effort to find some sort of a legal issue. It doesn't matter, I think, where the burden of proof is, because Williams met the burden. Williams proved that John Bumgarner retained all of the emails that he had exchanged with Mr. Armstrong. So there was a declaration that Mr. Bumgarner signed under declaration of perjury, stating that he did not delete or direct anyone to delete responsive emails from his account. That's at B4295. And then there was extensive testimony at deposition, which was then played in terms of videotape trial testimony, where ETE counsel was able to cross-examine Mr. Bumgarner.
Clement argued that it was not just Mr. Bumgarner, it might have been other sources, and it was not up to them to speculate about what other information might have been available.
Right, so that then does become, I would submit, entirely speculative. So the sort of idea that there could have been other unnamed and unknown individuals that Alan Armstrong was emailing with, that's not the kind of basis that Delaware courts have used to make adverse inferences. There was some other evidence that showed that this fact was non-speculative. So that's the sort of first point. The second point is, even if we had additional emails of this type, right, because we have the whole exchange between John Bumgarner and Alan Armstrong, even if we hypothetically had similar emails that Alan Armstrong sent to other people, that wouldn't change anything one whit, because none of these emails changes the unalterable fact that Williams did everything it needed to do. Williams was in a position, was, as ETE stipulated, ready, willing, and able to close as of the closing date. All obstacles have been removed. The favorable stockholder vote had been obtained. And so even if there were other emails sent, that wouldn't change anything.
Your time is running short. I would be interested in hearing what you have to say in response to your friend's argument on the fee shifting.
Yes. So this issue obviously arose, Your Honor, in the Shire case. In the Shire case, that was a 33% fee. Here, there was a 15% contingent fee. It resulted in a 1.7 times lodestar multiple. And the Vice Chancellor found that that was reasonable. So our argument is the test here is if parties write that there will be reasonable attorney's fees. It's been well established in many cases that date from before 2015 that reasonable attorney's fees means looking at section 1.5, looking at the 8 factors. The 8th factor there expressly is a contingent fee. And so the safeguard for whether attorney's fees are going to be reasonable, if the parties simply write reasonable attorney's fees, is the Vice Chancellor. And that was exercised here carefully. And if somebody in the future doesn't want to have a contingent fee shifted to them, they're obviously free to write that into their contract. A party can obviously write reasonable hourly fees if that is their preference. So these sort of public policy concerns about a provision like this are, with respect, overblown.
What about concerns about the timing of when you made this change in your fee arrangement?
Yes, Your Honor. So that happened in 2017. There actually was discovery taken of that, and the Williams General Counsel, Lane Wilson, actually testified that he assumed that role that year while this case was in process, that he had, while he'd been on the bench before that he had observed contingent fees in action, thought that they worked well, wanted to align the interests of client and counsel here, that it was his idea to ensure that alignment of interest, and that was why the fee was then entered into. So unless the court has any further questions, I would just end by emphasizing again that this is a case where the court below has now presided over 3 trials relating to this merger. The original expedited trial between Williams and ETE in 2016, a separate unit holder trial that also related to the same convertible preferred unit issuance, and now this trial has obviously had the opportunity to get into the record in great detail and observe the witnesses, and there's been no clear error shown in the findings of fact that were made below. Thank you very much.
Thank you, Your Honors. Just a few quick points in rebuttal. First, my friend began by reminding you that Williams was here before in an appeal seeking specific performance. I would only add that that was a non-expedited appeal to this court. The merger had, by the time this court heard this, the date for the merger, the closing date had long passed. That seems to me entirely consistent with a party that wants to preserve its right to collect a breakup fee, but is not actively pursuing the merger. More substantively, let me talk about the 3 issues that I mentioned in my opening. As to the adverse recommendation change, first of all, in trying to figure out what conduct could be an adverse recommendation change, I do think it's important to look first at 402D, which makes clear it's not just board resolutions amending board resolutions, because 402D itself says if you publicly propose a qualification or a modification, that's enough to constitute a company adverse recommendation change. But I also think 402F, the safe harbor provision, if you will, also tells you that it's not just sort of formal board actions that count. And of course, that makes sense because the board resolutions don't even have to be public. And if you look at 402D as a whole, it's clearly concerned about sort of post-approval acts that are going to change the dynamic. 402D covers both these company adverse recommendation changes. It also covers a company that would accept another competing merger offer. All of those things could essentially profoundly affect the deal, and that's why they're addressed in 402D. And 402F, as I say, makes clear it can be other things. And then I think S4, the Amendment 7 and the Amendment 8 are almost the prototypical qualification of the recommendation, because it's all well and good that the board wasn't unanimous to start, but Williams had been trumpeting their unanimous support for the merger for months. And then all of a sudden in late May, they amend, they qualify the S4 by saying that the minority of the board continues to oppose the merger. That seems to me almost the definition of a qualification that is adverse to Energy Transfer. So on the reasonable best efforts point here, first of all, one of the things my friend said that I think is very telling is in trying to justify the conduct of Armstrong, he says Armstrong decided that the best way to deal with Baumgartner would be to deal with them in this one-on-one conversation. But under the merger agreement, it's not just reasonable best efforts to resist, it's reasonable best efforts to cooperate in resisting litigation challenging the merger. So this wasn't under the best efforts clause. It wasn't Armstrong's decision to make. It wasn't Armstrong's decision unilaterally. He was under obligation to cooperate. He couldn't do all of this clandestinely, and he certainly couldn't cover it up, and he couldn't spoliate and then lie about it. And on the spoliation, I do want to be clear. My friend, when it was asked about the burden of proof, never denied that the burden of proof was shifted by the Chancery Court. And I think that's telling to his credit. But if you look at page 93 of the Chancery Court's post-trial opinion, which is at A5341, he says, turning to the second element, however, ETA has failed to demonstrate that Armstrong's destruction of his Gmail account ultimately prejudiced ETE. I don't know how you could more clearly put the burden on Energy Transfer, and I didn't hear a legal defense to the idea that when there is intentional spoliation, the burden has to be on the spoliator. It can't be on the victim. And I'll admit to speculation, but what else are you supposed to do when the other side destroys the Gmail account, the whole account, and then lies about it? You are forced to speculate that, of course, he would use this account clandestinely to communicate with Baumgartner. He probably used it with others as well. Just the last thing, being ready, willing, and able to show up, that doesn't cure everything you did beforehand. And finally, on the timing of the attorney's fees, I do think it's important because at the beginning of this, there wasn't a contingency fee because until our counterclaims were dismissed, both sides could face liability. It was only after that dismissal of the counterclaims and the only issue was the possibility of collecting $410 million that things changed.
Thank you very much, counsel. We appreciate the arguments. We'll take the matter under advisement.
Please rise.